Chairman, with that introduction, let me speak for the next hour and a half.
Okay. 2 minutes. We may vote the bill out if you do that.
If we won't vote the bill out, sorry. My name is Bryan Blevins, and I am president of TTLA for the 2015 year. And we are opposed to the bill respectfully. I would like to say thank you to Representative Villalba for having met with us and understanding and discussing our concerns. And we do look forward to continue to work with you, but we have deep-seated concerns about the bill, as you've heard from many, many other sources. And it's difficult, after having been here all day and listened to all the various comments and the gives and the takes, exactly where to jump in. But I have to start with the gentleman who just ended, who told you, where is SpaceX Incorporated? Delaware. Great. Where is SpaceX spending their money? Where are they hiring people? Where are they building infrastructure? It's here in Texas. And that's the difference between incorporation and operations. Incorporation may create some feed-based revenues, but operations is what's been building this state. And we're not just competing in jobs, we are winning in creating those jobs and those opportunities. The other thing is that I would actually argue respectfully that this bill is going to create a less certain environment. And here's the reason why I say that. This is not a mandatory or exclusive jurisdiction. In fact, the bill goes to great lengths to say that the jurisdictions are shared with our district courts. And therefore, these cases, either because a party files it in district court or a party files it in the chancery courts, these cases are going to be generating opinions and decisions and actions in two courts at the same time. We're going to have to take years to try to determine, how does this chancery court system work? What price will we pay as a result of that confusion in how we are going to integrate, assuming this legislature does, a chancery court system and court of appeals system with our existing elected officials. To give you an example of where I think that mechanically shows up was in the TRO example. And I'm not talking about injunctions, about the subpoena issues. I'm talking mechanics. Today, if I want to get a TRO, I'm going down to that courthouse. I'm going to look a judge in the eye. He's going to want to see me. I'm going to bring my witnesses if necessary. I'm going to file my documentation, and I'm going to give notice to the defendant, assuming that that's practical and required under the rules. Well, what happens then? Does that mean that they can run down real quick and file a removal? And all of a sudden, my necessary and speedy relief gets delayed because it's got to be remanded. It's got to be removed to the Chancery Court office in Austin. That Austin spins the wheel. It has to then go to some judge in El Paso. And then I've got to go to that judge in El Paso to get my relief. Honestly, he doesn't know me. He doesn't know if I'm a credible person or if I'm bringing him a credible case. I've got to give new notice. You can see where that would automatically, TROs and preliminary injunctions are about speed and stopping an immediate and irreparable harm, and there's a mechanical issue here that just isn't accounted for. I'll give it to you in the reverse. Let's say what if I want to file it in the Chancery Court? Well, how's that going to work? Because, again, I've got to file it in Austin. They've got to spin the wheel. It's got to get assigned somewhere. Now I've got to get there. But, by the way, I have to file my TRO paperwork in Austin. They have to get that information down to wherever the court is. From a TRO perspective and mechanically, it just doesn't work. I'll give you another example relative to the confusion I think we're going to see. One of the things not spoken about today has been that a district court would have the authority under the bill to certify a question to the Chancery Court. So if a judge thought that he wasn't capable but was having a matter of jurisdictional interest to the Chancery Court, that judge could certify a question. It's not clear whether a party can request that or not, but clearly a judge could ask that. Well, let's say the Chancery Court brings him back a ruling. What if it's dispositive of the case? Where do we go appeal? Are we going to appeal to the Chancery Court of Appeals because it was the Chancery Court's determination that resulted in the dismissal of the case? Or are we going to our existing elected Court of Appeals? There's a lot of mechanical issues, and look, I share all of the constitutional concerns and more. I share all of the strategic and local government issues and more. But mechanically, there are significant systemic problems that I'm not sure how we can account for. In addition to that, we have the jurisdictional question, and I appreciate Representative Yalva's discussion about how it's going to get trimmed down. We look forward to seeing that. But my fear, quite honestly, is this. Before this bill was ever filed, a executive summary was created and generated, and it went out. And so wherever the motivating factors are behind this bill, this is what their goals were for this bill. That it would create a statewide civil court of equity, that the jurisdiction of the court would extend to a wide variety of business-related litigation within the state, including actions against businesses, accusations of wrongdoing by businesses or their members, disputes between business, violations of the Business Organization Code, Finance Code, and Business and Commerce Code, that the Chancery Court would be able to issue writs of injunction, writs of mandation, writs of sequestration, writs of attachment, garnishment, and all other writs necessary. So wherever this comes from, there's a goal, and that goal is clearly not consistent with a limited jurisdictional perspective. We heard about in Delaware 44,000 cases in Delaware's Chancery Court, and it's supposed to be a court of limited jurisdiction. I'm sorry, 4,000? Oh, good. Okay, well, 4,000. In Texas, right now, the numbers would be that there's a set in the Office of Court Administration that talks about cases that are not personal injury, their debt, their contract, etc. Over 73,000 cases have been filed just last year in the debt, contract, and other civil category. There's a huge number of cases that could go to. Even if we assumed, and I understand, Representative, about the fiscal note concept and how we're going to increase the fees to cover the cost. But one thing I am concerned about is this. Because we have a case, it's going to be filed. Where would it be filed today? It would be filed in a district court or a county court. Who would get the fee? That district court or that county court. Now, that case can bypass our local government stop, go straight to the Chancery Court, and pay the Chancery Court fee. So what we've done is we've shifted dollars. It's not just about having a fee basis that's high enough to pay for the Chancery Court, but we haven't accounted for the money that we're taking out of the district courts. And unfortunately, those courts already cost the state significant dollars out of the General Revenue Fund because the filing fee system will not pay for the infrastructure of those courts. Another area that I just think has to be identified is this. In the bill, the Chancery Court will have the same civil jurisdiction as the district court. They will have all the powers, duties, immunities, and privileges of a district court. They will be paid the same as a district court judge. They can be removed and recusal motions for the exact same reasons as a district court judge. They will practice the same procedures of evidence and rules of civil procedures as our district court judges. But then we'll have a different judge who's supposed to try the case. I understand that this is not intended to be a slight to our sitting judges, and I appreciate that. But then when you hear gentlemen from the Business Law Foundation talk about how it's not a slight, but then they talk about, well, but they can only do one size fits all, and they give the example of a slip and fall case. Our judges are a lot more competent than that, and I can give you some numbers to back that up. Based on the 2014 Courts of Administration report, the current clearance rate in our civil courts is 93%. In terms of the civil cases are being resolved and disposed of within 18 months. And at the same time, our Supreme Court levels of petitions for review has gone slightly down, and most importantly, reversals are not any higher in the context of business courts. Our judges are not only doing it better than anybody ever has, but they're doing it wisely and inconsistent with the law because our Supreme Court isn't telling them they did it wrong. And quite honestly, even though we go through an entirely separate system, we pay for a separate system, we'll pay the fact that thousands upon thousands of cases will get tied up in the system. At the end of the day, the Texas Supreme Court is the one who will set our business law. because it all goes back to them eventually. Again, I think that there are many other systemic issues. They've been talked about at length. I appreciate the fact that so many people have come to talk about the issues. We are opposed to the bill. Honestly, it's not a solution looking for a problem. It's actually a problem looking for a place to land. Thank you, and I'll take any questions that you have.
I've got one question.
The challenge with this bill is that every person that's come here to testify has done a jury close. I mean, is that not the truth? I mean, I'm worn out of the jury closes, Mr. Chairman. Are you? I am worn out.
Thank you. Thank you so much. Appreciate it. Thank you.